Hi everyone, very warm welcome to fifth of our quarterly webinar that Sigma Risk is actually holding for our audience in Malta. So very interesting topic we have for today, and indeed a very well experienced, very knowledgeable panel that we have with us today as well. So we have representation from Malta Financial Services Authority. We have Dylan from MFSA joined us. Thank you, Dylan. And we have Roxane from Financial Intelligence Assessment Unit from FIAU, Alessia from Sanctions Monitoring Board in Malta, and we do have representation from the industry as well. So Owen, he is an AML financial crime compliance expert in the gaming industry, one of the prominent industry in Malta. So thanks to all of our panelists who joined us today, and many thanks to all of the delegates who have actually joined us today in this particular webinar on the ever hot topic of sanctions. And the focus today is all about sanctions, what it is, what kind of sanctions are they, and who can impose sanctions, for example. If we need some help and advice, who to reach out to. There are many questions that we will be talking about, discussing with our expert panelists, and you will all have opportunity to ask any questions in the Q&A function at the bottom as well. So please feel free to write down your questions, and wherever possible, one of our panel members will answer the questions today. So going back to the topic itself, so the reason for actually choosing this topic is purely on the demand from all of you. So on the back of our previous webinar, we did have one particular question asking you what should be the topic for the next webinar, and sanction has come up as one of the most sought after area where a lot of demand has come through. So that is the reason why we've decided that, okay, we will go ahead and proceed with holding this particular webinar on the topic of sanctions. Number of questions that we've received in advance asking about OFAC sanctions, OFSI, EU, Malta, UN sanctions, the applicability of sanctions in Malta on Maltese individuals or foreign companies operating in Malta. We will be talking all about that. We will also be talking about the tools, systems, automation, the best practices in case if we need some help and assistance, who to reach out to, who to get guidance from, escalations. Okay, there's a lot of things that the question that we have in our mind as well, or that some of them we have received in advance from all of you as well. So stay tuned. So this session is going to be very interesting, very engaging, very interactive. There's not going to be any presentation. That's what we have heard from you as well previously, that what you all like is discussion, real life examples, scenarios, questions, where we discuss between all of us for the benefit of the industry. So now, before I go and request our expert panelists to introduce themselves and their organizations and what role their organization play into making sure that the sanctions are very well understood, applied, and complied by throughout the Malta. So a brief introduction about myself. Some of you may know me already, but those who you don't know me, my name is Amar Ahmed. So I am the managing director of Sigma Risk. We are a financial crime and compliance consulting firm based out of UK, but very much operating all over the world. And Malta is one of the jurisdictions where we do have a big role to play. We've been working with the regulators, with the other agencies in Malta recently. And I had an honor and pleasure to be actually on the ground in Malta a couple of weeks ago. So it's been an amazing opportunity for me to come and meet many of you as well. So this particular webinar is, of course, arranged by Sigma Risk, and I'm also wearing another hat of International Compliance Association, who are one of the sponsors as well. So ICA is an organization which offers professional qualifications on different topics, including AML, financial crime, and compliance and sanctions as well. So thanks to ICA as well for helping us set up this particular event for the benefit of the industry. So now may I request our panelists one by one to please have a brief introduction about yourself for the benefit of our listeners and your role in your organization, and what does your organization do and what role do they play when it comes to the sanctions. So I will start with Alessia. Alessia, over to you.
Thank you, Omar, and good evening to everyone. Welcome to the seminar. We're very happy to be here and to talk about our bread and butter, actually. So I am Alessia Carbona, and I form part of the Sanctions Unit within the Ministry for Foreign and European Affairs and Trade. The name doesn't finish, but within the Sanctions Unit, we are the working arm of the Sanctions Monitoring Board, which is the national competent authority for sanctions implementation in Malta. As I have already said, we are responsible for all implementation of sanctions, and we will speak a bit more later on, maybe about how the board is composed and what we actually do. But I can already say that our focus is twofold, mainly education, which is the first role of the board, which is to educate people on sanctions compliance, and that is why we have very much welcome this the seminar on sanctions. And secondly, the aim of disruption of bad business, which is in breach of sanctions, and therefore ensuring sanctions compliance within our jurisdiction.
Thank you, Alessia. Very comprehensive introduction. I will move on to Roxanne. Over to you, please.
Thank you, Omar. Good evening, everyone. I'm Roxanne, and I am here from Malta's Financial Intelligence Analysis Unit, the FIAU, which is Malta's Financial Intelligence Unit and also the Anti-Money Laundering Supervisor. So I form part of the Guidance and Outreach team within the Legal Affairs section of the FIAU. And this team, the Guidance and Outreach, is responsible for drafting guidance to subject persons on the proper implementation of their AML-CFT obligations, but also it's responsible for training and outreach initiatives in general. So with regards to the FIAU's role with sanctions, it stems from an MOU, Memorandum of Understanding, which had been concluded between the FIAU, the SMB, and also other authorities such as the MFSA, whereby the FIAU acts as an agent of the Sanctions Monitoring Board, the SMB, and it assists it with monitoring subject persons' compliance with the obligations emanating from the National Interest Enabling Powers Act in relation to targeted financial sanctions which relate to terrorism financing, and proliferation financing. That is all from my end.
Thank you. Thank you, Roxanne. May I request Dylan, if you can please introduce yourself.
Yes, sure. So good evening, everyone. First of all, I would like to thank you, Omar and Sigma Risk, for today's invitation to this webinar. Practically today, I'm pleased to be part of this panel discussion together with my colleagues from the Sanctions Monitoring Board and also the FIU, whereby we work hand in hand towards same goals practically and objectives through our supervisory cooperation. As a means of introduction, I am Dylan, a senior analyst within the Financial Crime Compliance function of the MFSA. So practically the MFSA, as the single regulator of the financial services sector in Malta, regulates a variety of financial sectors, starting from banking, financial institutions, insurances, among others. So as an MFSA official, I form part of the on-site supervisory team, where we are responsible to carry out compliance interactions on MFSA license holders. So the plan today is to provide my views from experience gained during compliance interactions across different sectors in the financial services field and share them with you today. Looking forward.
Thank you, Dylan. Owen, over to you, please.
So thank you, Omar and Sigma UK Risk, for inviting me to this panel. I'm Owen, I'm a compliance professional, and I've been working within the gaming industry for the past 8 years, a little longer in the technology industry, specifically software. During these 8 years, I had the opportunity to work on various aspects within the gaming industry and also within different roles, such as IT auditor, consultant, and then I crossed over the fence, so to speak, and joined the industry as a professional. I've seen as well the developments that happened when 40ML directive came into force and gaming operators were subject persons. So I got to experience that and be part of that enforcement wave. Also later on appointed as an MLRO and actually managing the AML compliance program. Apart from Malta, I also worked in other gaming jurisdictions outside Malta, so that was very enriching personally, and to see the differences and the nuances between the European regulations and other jurisdictions. So I've seen quite a number of interesting things that I'd like to share today with you, into my perspective, and hopefully some helpful tips for those attendees that are in the gaming industry, but also in other industries.
Thank you, Owen. So a great introduction from all of you. I'm really pleased to have all of you today to join us at this session. So what is the next on this agenda now? Before actually we jump into some of the questions which are going to be very helpful for all of you to understand, I actually wanted to ask some questions from you first, from the audience, right? So that we, the panelists, we can understand which industries, for example, you're representing, etc. What role do you play, and what do you think about sanctions? So on a whole, so I have few polling questions that I'm going to launch now, and what I will really request all of you, it's just a click away. If you can please answer the poll question, that will help us understand as to what kind of pace and tone that we need to maintain throughout the session, and give us a better understanding around our audience as well. So all of these questions are totally anonymous, so please feel free to answer the way you want. So the first poll that should be on your screen now about your industry representation. So please, if you can select your industry of employment. So either you're from banking or law firm or gaming and entertainment, insurance, compliance, corporate services or other. So I will give it another possibly 10 to 15 seconds to give all of you to respond back. That will give us an understanding as a panelist as to who are our audience today. Okay, so 77% of you have already responded. That's been very quick. 82% responses so far. So let's give it another 5 to 7 seconds, and then we will close this poll. Okay, so I'm going to end this poll, and I'm going to share the result to you as well, so that you know as well as to who is actually attending this particular webinar. So we do have a mix actually of audience. We have individuals from the highest actually proportion is coming from other, and I would love to know actually which the other category there must be. So the banking, and we have gaming, entertainment as well, corporate services as well. So that's interesting, a good mix of representation. That's good to know. So the next poll that should be coming up on your screen now about your understanding on the sanctions. So what do you think if you have sufficient knowledge on sanctions, so that we can modify our approach or set the tone of our approach? If you think that you have a solid understanding around sanctions, that's the first choice. Or if you have a basic concept but would like to learn more. And then lastly, if you are quite new to the topic of sanctions. Okay, so we have responses from around 72% of the participants. So I'll give it another 10 seconds, and then we will close this poll as well. Okay, so let me share the results with you as well. So majority, around 2/3 of you who are attending today, they have basic understanding of sanctions, and there is a keen interest to know more about sanctions. That is very encouraging in the sense that although we have basic knowledge, but we are keen to know more about this particular topic. So that makes me even feel, much more happier to see that, okay, we are actually holding an event which can play a small role in actually enhancing your knowledge and understanding on sanctions as well. So the third poll that is coming on should be on the screen now. So do you think there is sufficient guidance and support available on complex sanctions matters? 1, if it is easily available. 2, available, but you have to strive hard to get to the right information. C, is very difficult to get formal advice and guidance. And the last one, that you don't even know who to approach to get the guidance if there is a sanctions matter on your hand where you need to make a decision, and what kind of support that you have available. So around 70% responses received so far. So let's give it another 5 to 7 seconds, and then we will close the poll. Okay, so I'm going to end this poll and share the result. I think this particular result should be a good source of information for the regulators here as well, right? So it clearly tells that if we look at the option number 2, many of you think that there is help available, but it's difficult to reach out. How can we make it better? How can we make it easy? How can we have the information more readily available? So and also, and then around 25%, 26% of you think that it's really difficult to get the formal advice. So if you add these two numbers, 55 and 26, around 80% of the audience today, they think that either the information or guidance may be obtained, but with a lot of difficulty, or it is not available. So this is something possibly could be thought about from the information sources perspective, that how this information can be, or support could be made available as easily and as swiftly possible. Okay, so another poll that is going to be here. I've just launched it. What kind of training on sanctions is offered within your organization? That is very interesting one. As to find, we do expect a lot from the regulators, but what the organizations are doing for themselves, for their own staff members. And again, it's purely confidential, anonymous, so nobody knows who's answered what. So please feel free to give your answer in confidence. Okay, so either you have very detailed and comprehensive training available by your employer, or a very basic type level of training, or there is no formal training at all. So I have 70% participation in the poll so far. So let's give it maybe another 5 to 7 seconds to get as many responses as possible. Okay, I'm going to close this poll and let's share the results. Here we go. So that is interesting. It's quite interesting to me as well, that it's only actually less than 10% of you think that you do receive a detailed and comprehensive training on sanctions within your organization. So this is something maybe more emphasis can be placed as well from an organizational perspective. Majority, 58% of you think is basic level of training provided, and then 1/3 say that there is no formal training available at all. This is something quite important, and I think that's I'm quite pleased in the sense that we have actually asked this question, which should even trigger the organizations to think about providing a bit more training on sanctions as well. So thank you very much. Last question should be on the screen, and then we will head to our panel discussion. Here we go. So how does your organization screen for sanctions? Do you have an automated screening in live environment or automated screening on periodic basis every day, 3 days, every week, 2 weeks, month? Or do you do manual screening, periodic or ad hoc basis, or excuse me, or if you do not conduct sanction screening at all? Okay, so we do have 63% participation into this poll now. So maybe I will give another 5 to 7 seconds to get some more responses. Okay, so let's close this poll and let's share the results, which you can see on the screen. That majority of you, that's a really good news. 44% of you have automated screening going on live environment, quite encouraging. And 31% on periodic or basis, 17% manual screening, and there is some responses which says that they do not conduct sanction screening, something that may be a good idea to consider as well. So that's all. We are all done with all the polls. We have got some really good idea as to what do you all think about sanctions now. A brief reminder, please feel free to put the questions into the Q&A section. And then when we have finished with our panel discussion, we will try to answer as many questions as possible. So now I'm going to head to my expert panel here now for some of the questions that I had in my mind as well, and some of them we have received from our audience as well. So I'm going to kickstart from the main authority here in Malta, the Sanctions Monitoring Board. Alessia, I will come to you now. What I would like to hear from you a little bit more for the benefit of our audience as to what really are the functions of the Sanctions Monitoring Board. And considering its wide and varied membership comprising different government entities, what does really Sanction Monitoring Board strive to achieve? What role do you play? So if you can elaborate a little bit more for our audience, please.
Sure, and I'm hoping now that those who didn't know who to contact know now that it is us, the Sanctions Monitoring Board, when they have any query relating to sanctions. So as I already said before, the Sanctions Monitoring Board is the national competent authority for the implementation of sanctions. And to do this, we do this in various methods. So firstly, we try to issue guidance notes to guide the sectors, the different sectors, especially when the waves of Russia sanctions were rolled out. We try to issue as much as possible guidance notes, which are all the time changing, unfortunately, but that is due to the progression of the recent waves of sanctions. We also issue rulings. We also consider any listing proposals, meaning whether a person should be on a list, or a person or legal entity, I must say, should be on a specific list, be it of the UN, EU, or a national list. We also consider delisting proposals. So if a person feels aggrieved that he is on a list, he could come to us and give us the reasoning why he should not be on a list. Of course, if it's a EU or UN listing and not a national listing, that would have to be considered in another forum rather than by us. But we also deal with these. We also receive for applications for authorizations for derogations. So derogations are envisaged in the legal acts, and therefore we consider derogations, for example, for unfreezing of certain funds in order for certain expenses to be paid, such as legal expenses, living expenses, expenses related to taxes. So these are all derogations that we have to consider. We also issue fines. So as we have our memorandum of understanding with MFSA, FIAU, and MGA, who do the supervisory aspect of our job, we also issue fines on the findings that they find. And of course, we have to give reasons why these fines are being imposed, and we also can make regulations, issue also legal notices and others. We also have some powers relating to the access of information, and therefore if we need anything from any authority or any economic operators, we can ask for that information, and we also prosecute put forward investigations to the police to prosecute any sanctions breaches.
Thank you, Alessia. A quick question now, a follow-up. You did mention now that everyone should understand that who to reach out to. Is there a formal channel in place? Like, is there some kind of portal they need to raise a request, or they give you a call or send you an email? What is the mechanism for anyone to get in touch with Sanction Monitoring Board for any advice?
So we generally adopt the approach that everyone should send an email to our generic email address, which is sanctions.smb@gov.mt. And we obviously see to those requests. Of course, sometimes it does take some time. One, because we were overwhelmed with the Russia sanctions, the huge amount of queries that we got. And secondly, because you have to appreciate that we are sanctions experts and not experts in every sector. And therefore, these are sector-specific sanctions, and we have to understand firstly the sector which we are dealing with, and that requires a lot of toing and froing with other authorities. May I remind that the SMB is made up of 18 authorities, actually, with the chairmanship sitting at the Ministry for Foreign Affairs. And therefore, we are made up of various entities, which we are all the time consulting with in order to give the best possible replies.
Thank you. Now, sorry, I'm going to ask another question to you now, Alessia. So, for example, if I'm a market participant and I have a query, do you have any rough guidance as to how long can it take to receive a response, roughly? I know there cannot be a hard and fast answer. It will really depend upon the actual query itself, but any rough timeline in place at all? Also, what do we do while we are waiting? So for example, if we do have, for example, a particular situation where we need some urgent help, but we have sent a query to you for advice, what do we do in the meantime? Do we just sit on the query or any transaction or anything? What is, the best course of action for the industry while they're waiting a response from Sanctions Monitoring Board?
So regarding the timeframes, I would be very hesitant to give any type of sort of timeframes. I can assure you there were people who we responded on the same day, but there were other people who had to wait quite a bit of time. But that's because of the toing and froing with the other authorities, just to understand certain specificities of the industry. We also recommend that when you send us a query, include all the details, or as much as detail as possible that you can share with us, of course. That would give us a better picture and would also avoid toing and froing between us and yourself in order to get the full picture, I would say. Secondly, I would also suggest that if you are seeing that we are taking a longer time to reply, to give us a phone call and try to get any one of us on the phone. It's not because we wouldn't have seen your query, but to give you as a status update on where your query is. Thirdly, we do not substitute legal counsel. Therefore, every economic operator is expected to seek out legal counsel, and that is the responsibility of the economic operator. We can just issue guidance, then it is the prerogative of the economic operator as to whether it would be beneficial to go with the advice that we gave, or whether they could seek other courses of action. And that is normally done through legal counsel. We are in no shape, way, or form substituting legal counsel.
Thank you, Alessia. That's really, really helpful. And I think this is something that I should have actually mentioned earlier as well. So this particular setting here, this webinar, again, what we discuss here, it is purely for your benefit, in the sense that we are sharing our understanding and experience for any situation where you need some advice. Again, whatever we discuss here is not going to be an alternative to a formal advice. Right? So please make sure that you do reach out to the competent authorities. If you need to go to experts in terms of formal legal opinion, that is something that should be the best course of action. So thank you, Alicia, for picking up on that particular point as well. So now I'm going to move on to Dr. Roxane. So FIAU, the name very well known in Malta. So what is it that FIAU's role in regards to sanction? Is there any guidance that is provided by FIAU at all? And if it is, then where it can be accessed from?
So thank you, Omar, for your question. So let me start first with on the FIAU's role with regards to sanctions. So guidance provided by the FIAU, such as the implementing procedures, the IPs and shores, are intended to assist subject persons to understand and fulfill their obligations under the Prevention of Money Laundering and Funding of Terrorism regulations, the PMLFTR in short. However, subject persons have to undertake also other measures at law aimed at combating MLFT, which do not emanate from the PMLFTR or the IPs. And an example are the obligations which emanate from the National Interest Enabling Powers Act, which relate to sanctions screening, freezing of assets, and reporting. Now, while the competent authority responsible for ensuring compliance with these obligations is not the FIAU, but is the SMB, subject persons may still be required to provide the FIAU with information on their sanction screening policies, their procedures, and their implementation whenever the FIAU would be carrying out a supervisory examination. And this is because, as I explained briefly earlier in the introduction, in view of a memorandum of understanding which had been concluded between the FIAU, the SMB, and the MFSA. And through this MOU, the FIAU acts as an agent of the SMB and assists it with monitoring compliance with the obligations which emanate from the NIA in relation to sanctions. And then any findings are reported to the SMB for any subsequent enforcement action as envisaged under the National Interest Enabling Powers Act. I would also like to mention that the FIAU also cooperates with the SMB and is advised of any updates and news from the SMB's end which affect subject persons. And then the FIAU circulates this information which would affect subject persons, such as when new sanctions are issued, etc., via a newsletter, which can also be found on our website. So we try to circulate the information from our end as well. Now, with regards to guidance provided by the FIAU, I think this would be helpful in view of the response that we had earlier from the poll. So in March of this year, the FIAU has issued a guidance note on the sanctions adopted in response to the situation in Ukraine. And the aim of the guidance note was to remind subject persons of their obligations under the National Interest Enabling Powers Act, and also how sanctions may impact subject persons' obligations under the PMLFTR and the IPs. Now, the guidance note stated that insofar as AML CFT obligations are concerned, subject persons should pay attention mainly to risk understanding and assessment, to beneficial ownership, and also to transaction monitoring and reporting. Now, I'll be delving briefly into each topic as to the salient points that were mentioned in this guidance note, and I would also like to advise that this guidance note can be accessed from our website. So if you didn't know about it, you can go on our website and read through it. So when it comes to risk understanding and assessment, the imposition of sanctions is one of the factors that obviously would need to be considered when subject persons assess the risk of MLFT associated with a given jurisdiction, as well as the risk of MLFT arising from the customer or, where applicable, from the beneficial owner. Now, such imposition of sanctions should lead to a revision of one's overall risk assessment for business relationships, and should also be a determining factor in assessing the risk associated with onboarding a prospective customer. Subject persons should also pay attention to any adverse media which puts a prospective customer or a beneficial owner in proximity of an individual who is subject to sanctions or restrictive measures. Now, when it comes to beneficial ownership, subject persons were advised that the imposition of sanctions and restrictive measures may lead to attempts by beneficial owners targeted by these sanctions or restrictive measures, or those who consider themselves likely to eventually be subject to similar sanctions or restrictive measures, to distance themselves from the entities or the legal arrangements that they own. And therefore, in such instances, subject persons should pay more attention to whether any attempt to divest oneself of beneficial ownership is genuine, or else whether it is merely an attempt to conceal the actual beneficial owner, whilst the original beneficial owner retains control over the entity or arrangement through other means. Now, when onboarding any new customers and conducting their screening for adverse information, same as I mentioned for the previous point, subject persons should pay particular attention to information which may place the customer or the beneficial owner in proximity of any sanctioned individual or one that is very likely going to be sanctioned. And should any such recent and credible information surface, then subject persons are to pay more attention as to whether the individual requesting the subject person's services or who is otherwise declared as the customer's beneficial owner is appearing on behalf of someone else. Moving on to the last point on transaction monitoring and reporting. So when carrying out transaction monitoring, subject persons need to pay additional attention to possible activities and/or transactions pointing to a customer being in breach of sanctions. Now, particular attention should be paid to those customers who the subject person knows to have significant dealings with countries that are subject to sanctions or restrictive measures, or that otherwise have close contact with individuals who are subject to any such sanctions or restrictive measures. Now, it is important to note that with regards to the AML CFT area, reference is not only being made to those sanctions and restrictive measures which are legally binding and enforceable in terms of the NIA, but also to those imposed by jurisdictions like the United Kingdom through the Office of the Financial Sanctions Implementation, or else the United States through OFAC, and also other jurisdictions. And this means that even though these other sanctions and restrictive measures are not legally binding under Maltese law, they still have a bearing on the application of AML CFT measures by subject persons.
Thank you, Roxanne. That's very, very comprehensive opinion from FIAU. And you raised some really, really interesting points as to what are really the obligations of the subject persons are, and what are the expectations when it comes to from FIAU perspective. So we will definitely talk about what is your expectation, for example, when you conduct on-site supervisory visit, etc. What do you look into? I will come back to on that particular point shortly, but now I would like to go to Dylan from MFSA. Please tell us a little bit more about what is the role that MFSA plays in sanction compliance in terms of guidance, policies, and supervision. So this is something we all keen to know as well from MFSA perspective as well. Dylan, over to you.
Yes, sure. Thank you, Omar. So starting off from an MFSA perspective, the Financial Crime Compliance Function works closely with several entities, including the FIAU and also the Sanctions Monitoring Board. And through its supervisory objectives, FCC is engaged with the SMB in terms of an MOU, as Roxanne rightly mentioned earlier, whereby the MFSA cooperates with the SMB with the aim to ensure that the financial sector complies with the requirements stemming from the National Interest Act. So as part of the examination process, checks are performed on subject person systems, policies, procedures, and controls practically, which are aimed towards compliance with the local sanctions regulatory framework, while also promoting to raise the bar in line with the competent authorities' expectations practically. However, in addition to the supervisory cooperation with the SMB and the FIAU throughout the compliance examinations, the MFSA is also responsible for the granting of authorizations to persons seeking to carry out financial services activities within the financial sector in Malta. So practically authorizations is an important part of the overall supervisory framework that is adopted by the MFSA, and hence due diligence is being performed on proposed and also existing individuals and corporate shareholders and other key function holders of proposed and also existing license holders. So the authorization process of entities seeking to enter practically the financial services industry in Malta is a key function of the MFSA in its gatekeeper's role. So the aim, the exercise practically is aimed towards assessing whether the applicants, the proposed and existing applicants, are fit and proper to fill their role in terms of integrity and reputation within the context of the wider fitness and properness assessment. From a guidance perspective, the MFSA is also actively engaged with its license holders by issuing public notices to remind subject persons of their obligations, to ensure that they have effective systems and controls in place, and to ensure that they screen their customer base from a sanctions perspective in line with the regulatory obligations. In its circular also, the MFSA always reminds its license holders to contact the SMB if there are any doubts with regards to a particular relationship, for instance, or a transaction with direct or indirect link, practically to any applicable sanction list.
Thank you, Dylan. Really appreciate your comments on that and really explaining exactly what crucial role MFSA plays when it comes to sanction compliance, guidance, and supervision perspective. So I'm going to our industry expert now. Owen, over to you. What do you think? What are the really practical considerations, for the industry to make sure that we do achieve compliance with sanctions as an industry perspective? How do you look at sanctions? What can you do, or what can we do as a member of the industry to make sure that whatever is the expectation from our local regulators, as well as sometimes the regulators from around the world, where we may need to actually comply as well. So tell me a little bit more from industry perspective as well, please.
All right, so we are in Malta, and we're discussing, obviously, regulators and these bodies that are attending on this panel in Malta. But there has been quite a shift in the gaming industry in the past couple of years, where there are new gaming jurisdictions that have licensed, take for example Sweden in 2019, but also other jurisdictions outside Europe, where previously you could use the MGA license to operate in that jurisdiction. So I resonate that comment that Roxanne made earlier, that you don't really need only to adhere to what the SMB or the FIAU or the MFSA tells you, but if you're operating under a license in that jurisdictions, that foreign jurisdiction, you also need to follow what sanctions body is telling you to do in that jurisdiction. Okay, so that's the first point. The second point is, when we talk about gaming, there's the brick and mortar side and there's the online aspect. With online, transactions are done in microseconds. It's really fast paced. You cannot do that manually. You cannot do sanction screening. It's impossible. It's humanly impossible. All right. And in fact, I was also a little concerned when I saw the polling results earlier, when there was still a significant percentage that respondents said that there was manual screening or no screening, right? And also that the reach of expertise is not readily available. Okay, so in terms of the expertise available, I can say that as an advantage in this jurisdiction, I spoke to many professionals, many seasoned professionals who have the knowledge, and that knowledge is easily accessible. So another practical recommendation here is that if you do not have that knowledge in-house, or you can't access training immediately, you can seek out the help of seasoned professionals to actually come in, give you tips, to explain why it is important to do the sanction screening. So obviously there was mention as well of the guidance note earlier. What are the implications? You have fines, as Alessia mentioned. There's also imprisonment. And yeah, the directors and the top level management need to be aware of these risks, right? So compliance professionals, I totally understand some of your frustrations in order to carry out this awareness, but keep trying and keep explaining. That is your mission there, okay? To keep everyone aware, because obviously training and awareness is also another crucial aspect here of what is the implication. So you need to keep your senior management aware. They're probably relying on you. They wouldn't know. This is a very specialist topic that we're discussing nowadays. So your director might be knowledgeable in his business development, how they're going to create more business, how are they going to roll out marketing strategies, but they wouldn't know what the National Powers Act, for instance, is. So it is your mission as a compliance officer to make people aware and have conversations, and not just long conversations, keep reminding them, you know. So that is another advice. So we touched upon that topic where it is impossible to do the manual screening. Yes, there are very good solutions available out there. You need to assess not only the price, but what you're getting. Do these solutions maintain their own lists? Do they curate these lists themselves? Do they buy them from another provider? And there are also fancy solutions that use artificial intelligence, for instance, to detect patterns, okay? So I can tell you that there's a lot available in terms of automation solutions on the market. And I would suggest you network. There's the gaming community holds a lot of conferences. There's one happening this month that's also very important in the annual gaming industry calendar. And I'm pretty sure that these representatives of these solutions will be more than happy to explain what is available there.
Thank you, Owen. Well, you have raised a very good point. I'm glad that you have raised on automation and solution. One thing that I have seen, that there are millions of solutions out there. It looks like everyone has kind of given up on their other careers and started building software solutions on sanction screening, transaction monitoring, KYC, CDD, AML. There are like, I think more solution providers than actually the solution users these days. So it is really important that we, as a user, conduct our own risk assessment on the solution. Does it really work? Now, you can have really fancy looking solution, and when you look at a solution, you may think, wow, that thing is going to resolve every problem that exists on this planet Earth. But actually, this is just a solution. There's a good interface, good output that you see, but is it really a correct output? That is something very important. I have been using solutions. I've been creating solutions. One tip that I will give to all of you here is that do test the solution provider rigorously on two angles. One is the reliance. How much reliance can you really put on the solution? And B, the knowledge and understanding of the solution provider. How do they really understand the subject matter as well? And C, test it, test it, and test it. Whenever I speak to a solution provider, I always have my scenarios in my pocket. I take it out, and someone comes and tells me, hey, I've got this excellent sanction screening solution here. And I would say, okay, that's perfectly fine. Can you please search for this particular individual? And I would like to see the output myself. I've got an excellent solution in PEP screening, for example, a really good IDNV solution. And I always come back with my own problems, I would say, which I know that they do exist. And I ask these questions, they do demonstrate it to me that what you're saying, it actually works. That is very important. Also, when it comes to the regulators and the enforcement, you can never get away by saying that the reason why we, for example, failed to identify a possible sanctioned individual because our system did not pick it up. So is the fault of the solution provider? No, the regulators don't buy that. Okay, all over the world. What the responsibility is within the subject person. It is the role of the subject person to make sure that whatever solution they are using, that solution is fit for purpose and it does the job which it should do. So please be very careful when you get to the solution providers. Many of them, and some of them actually don't even understand the subject matter itself. So that is something very important point that I would like to make. So now going back to my panel, the next question that I would like to ask. Now we're talking about Malta. What, of course, we do have sanctions, guidance in Malta, but of course we live in a global village. We have clients from around the world. We have staff members from around the world. We sometimes operate in multiple jurisdictions as well. Sometimes we buy and sell from multiple jurisdictions. Sometimes we transact across the world, right? So different currencies, different softwares, etc., etc. So what I would really like to know, let's hear it. I'll come to you now. What sanction regimes are really applicable to you, to Malta? What we should be thinking about? And then I have two follow-up questions now. So do sanctions apply to Maltese nationals if they commit a breach outside of the European Union? Say if there is a Maltese individual or company who conduct a breach of sanctions, say in Canada, for example. Or second scenario is that how about the regimes of the third countries? For example, would a Canadian or British or American or any other sanction regime apply on Maltese companies as well, or Maltese individuals as well? I would like to know a little bit more about the extra territoriality aspect. What is the opinion from your perspective?
So thank you for these questions. So let's start from the first question, which are the applicable sanctions? So it's quite straightforward. So we have the United Nations regimes, the European Union regimes, and also national regimes. Up until now, we do not have any national regimes, so lesser burden, I would say. So until now, the only two regimes in the sense that we have the UN regimes, there are a couple of them, and the EU generally adopts those of the UN and adds to them. And then the EU also has the autonomous regimes. So those are the ones applicable in Malta. As you rightly pointed out, there are a number of jurisdictions that have various regimes. Some of them align with those of the EU and others which do not. So starting with our neighborhood, we have the Western Balkans who are invited to align with us. There is the EAA countries who are also invited to align with the European Union regimes. Some of them do, some of them don't. Then you have to make your own assessment, which one does and which one doesn't. But then there are also our British friends who used to be part of the European Union, and they carried most of the EU regimes forward, and they have also their national regimes. And then which is quite particularly, I would say, is the US. The US has a vast range of regimes, and some of them are aligned with the EU, but others aren't. And the particularity about the US regimes is that these are extraterritorial in nature, and therefore they do not apply solely to the territory of the US or to US nationals, but also around the globe according to them. This differs from what is the opinion of the European Union about extraterritoriality. And in fact, in the EU, the regimes only apply within its territory and to its nationals, being legal or otherwise. And you asked me to whom are sanctions applicable. So these include natural and legal persons, but also it is important to bear in mind within our jurisdiction that these also apply to registered aircrafts and registered vessels. So any Maltese vessel or a registered aircraft, wherever they might be, are subject to EU sanctions. And I mean, this is quite important for us, of course, given our the size of our registry. Shipping registry, that is, we have the 6th largest shipping registry in the world, so our vessels do give us a bit of a headache sometimes. If let's say there is a Canadian who is here and who is within our territory and breaches sanctions, he would also be liable to any breach of sanctions. Like so, if there is a Maltese in Canada who breaches EU sanctions, then he will also be liable to sanction, to our courts having jurisdiction over that. It is important to say that if a Maltese breaches Canadian sanctions, he will not be liable under Maltese law. He will be liable under Canadian law, but we will not go after that person, of course. The most important thing is to watch out for the EOS, I would say. So they are not applicable. OFAC sanctions are not applicable in Malta, but they do extend to Maltese in the sense that if you deal in the dollar, if you are buying stuff from the US, if you are exporting to the US, if you employ a US national, you might have extraterritorial effects being imposed on you. We call them secondary sanctions. Nevertheless, I will stress this again, we are not the Maltese courts, the Maltese system will not go after anyone who breaches OFAC sanctions. But we do encourage through our guidance note to look at the reason why sanctions were imposed by the US. Therefore, what you need to safeguard the totality of the jurisdiction. And if someone was sanctioned because of corruption, because of terrorism financing, these could all affect our jurisdiction. So we encourage anyone to see the reasons behind the listings. Another note which I will like to mention is that the EU has a special legislation also, which is called the blocking statute. It's a particular regulation which stops the extraterritorial effect of certain US sanctions. These are very particular. These are the Cuba and the Iran sanctions, and it safeguards economic operators from being subject to secondary sanctions, which are being imposed on the US. And therefore, the EU is trying to stop this extraterritoriality principle. I think I have answered all your questions, but feel free to ask away.
Thank you, Alessia. That's really spot on answers. So I think it is important point that you've raised, if I have understood it correctly, is that in Malta, the courts will not enforce OFAC sanctions. But the point is that we live, as I mentioned before, in a global village. We do use US dollars to trade, right? So especially if you come to banking industry, for example, if we want to maintain a correspondent banking account in another jurisdiction for USD, we still do need to worry about OFAC sanctions, right? So if we have staff coming from US, or if we have a subsidiary in US, okay, then we do need to worry about OFAC sanctions as well. Although maybe a Maltese court may not go after you, but that does not mean that you are safe from the US courts as well. But if we are trading, if we are working all over the world, and then there could be consequences down the line, if not from Maltese authorities, but from from US as well. And then this is a very comprehensive concept of US person. This is something that I have discussed many times previously, there are a number of ways where the US sanctions can be actually applied on a company or an individual. So, for example, if you are a US green card holder residing in Malta, for example, or if you are Maltese citizen and you've visited USA, for example, or if you're an institution who have a sister entity in USA, or if you are a subsidiary of a US entity, or if you buy or sell products which have a US technology, US origin, right? So there are number of angles which can kind of, make you a US person. You do not have to be a US citizen to be a US person. There are many other things which can actually capture you under the definition of a US person. So I would say it is very important that all of us, we understand as to what are sanctions, how they can be applied, and how things can sometimes go wrong as well if we do not take it seriously. So that is kind of what I really wanted to share from my end. Now I would like to move on to Dylan from MFSA perspective. Please talk a little bit, give us some more information about how important it is to screen for sanctions and for subject persons, risk exposure. What can go wrong if we don't screen for sanction, or if we don't have a solution which does the job? So as MFSA, what is your expectation from the industry, from the sanction screening perspective?
Yes, thank you, Amar. So practically, local subject persons are obliged to undertake measures at law practically aimed at combating terrorism, terrorism financing, and also the financing of the proliferation of weapons of mass destruction. So in light of the continuous expansion and also growing complexity of international sanctions regulations, let's say, subject persons should ensure to have effectively implemented a robust sanction screening framework, which is ultimately aimed to detect, prevent, and also manage sanctions risks. So the procedures, systems, and controls should be clearly monitored to ensure that the client base and related parties within the business relationship of that particular subject person are immediately screened after there is a change to the directly applicable sanction, this as Alexia rightly mentioned. So as with the management of all financial crime risks, subject persons should first identify and assess the sanction risks to which they are exposed to, and subsequently be able to implement a sanction screening program proportionate with its nature, with size, and also the complexity of the business. So in a nutshell, for an effective sanctions framework, one would be required to carry out a self-sanction risk assessment in order to assist on the identification of inherent sanction risks emerging from a number of the subject person's activities. So starting off with the product, for instance, one would need to take into consideration what products and services are offered by the subject person and whether those products represent a heightened sanction risk. It is also important to mention the customer base, for instance, whether the customers are international or domestic, where these customers are located and what business they may undertake, the channel of distribution, that is also important to take into account, the jurisdiction connection of the customer and also the transaction activity. And the last point would be in terms of transaction activity, the complexity, the frequency, value, and also the volume of transactions being processed by the subject person. So these are important points that subject persons should firstly consider to identify the sanctions inherent risk, ultimately being able to develop procedures and controls that are aimed to mitigate obviously the risks, coming up with a residual risk which is in line with the risk exposure and also the risk appetite of the subject person. On the other hand, unfortunately, an ineffective sanctions compliance program can lead to severe repercussions The breaches of sanctions violation, even unintentionally, entail heavy penalties and can lead also to serious destruction to the institution's credibility mainly. There's the element of reputation, the liquidity problem, and also the performance of the subject person itself. So in a nutshell, it is important that subject persons emphasize to have an effective sanctions screening framework.
Thank you, Dylan. That's really helpful. I'll come to Roxanne now. From FIAU perspective, what I would like to know for the benefit of our audience, when FIAU conduct supervisory visits, on-site visits, do you look into what kind of sanctions control framework is in place? Do you look into what kind of systems and tools do they have in place? And do you kind of make an assessment on the effectiveness of the sanctions, compliance framework of the subject entity? So that's what I would like to know, whether the sanctions angle is part of your on-site supervisory assessment as well.
So yes, so the supervision section within the FIAU carries out supervisory examinations on natural or legal persons who conduct relevant financial business or relevant activity in terms of Regulation 2.1 of the PML-FTR. Now, during the supervisory examinations, yes, checks on sanction screening policies, procedures, and also their implementation are carried out in order to ascertain that subject persons are adhering with their sanction screening obligations and that they are effectively implementing them in their day-to-day activities. So when it comes to sanctions, what does the FIAU look out for during supervisory examinations? So with regards to internal controls and procedures, during supervisory examination, officials would check whether subject persons have policies and procedures which explain how the subject person applies sanction screening, and they would also check whether the policies and procedures make reference to the prohibition of employees and officers from disclosing to any customer or any third party the fact that a freezing order is to be applied. Another thing is that during visits, it will be verified whether subject persons have measures and systems in place that regularly check sanction lists and which screen on a regular basis prospective clients and also the current client databases against the relevant lists of designations to determine whether any prospective or current customer or beneficial owners or any party to a transaction is a designated person. The subject persons during visits would also be asked to which lists they refer to in order to screen their customers. And if subject persons make use of automated systems, then such systems would also be checked to determine whether these systems are actually able to identify the customers and beneficial owners which are subject to targeted financial sanctions on terrorism and proliferation of weapons of mass destruction. During the visits as well, the sample files and the review would be reviewed and they will be checked to determine whether they have actually undergone any sanction screening to make sure that subject persons actually carried out sanction screening. And officials carrying out supervisory visits would also take note of whether subject persons have identified cases where potential or current customer beneficial owners were a designated person or entity. And also, note would also be taken of whether any targeted property had been identified and frozen by the subject person, and whether there was any attempt to carry out transactions involving identified targeted property, and whether any relevant reports were actually filed with the SMB as required under the NIA. Now, following the supervisory examination, the FIAU would then notify the SMB of any potential breaches in relation to the subject person's compliance with their obligations under Article 17.6 of the National Interest Enabling Powers Act. And as explained before, this is because the FIAU merely carries out the checks on behalf of the SMB, and then once the FIAU forwards all the information and findings to the SMB, it would be up to them to sanction for any breaches, should there be any.
Thank you. That's really helpful to understand that FIAU actually kind of put a lot of focus on sanctions when it comes to the on-site visits as well, and then you do actually dig deep into the the effectiveness of the compliance framework from the sanctions perspective as well, and the collaboration that you do have with the sanctions monitoring board. Now coming to let's hear to yourself from fine if FIAU has kind of notified you in the sense if there are any gaps in the control framework from sanction perspective, what kind of enforcement powers do you have? Can you recommend to cancel a license? Can you recommend to issue a penalty? Or if there is a some action that need to be taken, what kind of action SMB can take?
So as Roxanne and Dylan explained, they carry the on-site visit. We receive the reports, then we analyze the reports, and we issue a letter to the subject person, and with the failings, if there are any, and we give them an opportunity to reply. So ensuring due process is adhered to, and if we still believe that there are breaches, we can impose fines in terms of Article 19 of the National Interest Enabling Powers Act. These obviously relate to breaches under Article 17.6 relating to screening of subject persons and the failure to inform the SMB of any frozen property, for example. In cases of potential breaches of sanctions, actual breaches, then the file will be passed on to the police for further investigation, and it is up to the police whether to continue prosecuting. This would be a criminal procedure then.
Thank you very much. So there is clearly a lot of collaboration between the authorities over here, making sure that we all work together to with the common goal of kind of ensuring that we do achieve compliance with sanctions as well. So that's a really good kind of collaborative effort, I would say. Now talking from the industry perspective, so that there are a lot of expectation and collaboration going on from from the regulators. Now Owen, I would like to come to you. So there are a lot of expectations. Now, what can industry do? Maybe automation is something that we can bring in, but the question is that does automation resolve all of your problems, or is there any things that that you would like to mention as the key challenges within the automation, and then how can we possibly tackle those challenges, like false positive or things like that? So you may want to shed some light on that.
All right, so earlier we said manual screening in a high volume environment is humanly impossible. 100% automation, we're probably a few decades away until the technology matures. And there is still a margin of error there, depending on how you configure your system. You mentioned the word automation, but I feel that word is used perhaps a bit too loosely. If I am inputting the details of a sanctioned individual on a portal and then it goes to search, that is not really automation. By automation, and we have to make a distinction between automation and orchestration, okay, in tech jargon. So when we talk about automation, we're talking about the workflows. Let's say a player signs up, that fires a trigger onto your provider for sanctions, and you get the result in a few seconds, hopefully, or at least that is the service level agreement expectation. Okay, but then does it stop there? What are your triggers? And are you responsible for querying the provider every time when you want to do a check? Or you just input the name once and the provider will do periodical screening for you? Obviously, these are also tips that you might use when you are negotiating with your provider as well, because you are placing a certain amount of reliance on their technology to help you comply and ultimately make your life easier. But if your provider is failing you, then, as obviously my colleagues mentioned, there are implications on the business and the directors. So what are we saying here? Too much automation has its risks. Manual job has its risks as well. I often see that technology professionals need a lot of guidance in terms of what to implement. So as a compliance professional, you don't only need to make people aware of the regulatory requirements, but you also need to ensure that the project of such an automation is implemented correctly to the full, and that you need to test the effectiveness. Now, testing the effectiveness should not be done when when an FIAU inspection is being carried out, for instance. No, you should have that in an internal audit program, okay? So, because it's better for that to be detected. Even better if you can allocate time as a compliance officer to run, to carry out sample checks and inspections yourself, okay? So to conclude on this point, yes, there are challenges because the technology is still maturing. As we said earlier, there's a lot of options available. When selecting a provider, you should do your due diligence. You should ask them, who are your customers? In what jurisdictions do your customers operate? Okay, especially for gaming. Now that having one regulated jurisdiction has proven that you cannot survive in today's conditions. Nowadays, you need to operate in multiple jurisdictions, right? Regulated, depending where you want to onboard your customer and what are the products that you are going to promote.
Thank you, Evan. That's really helpful. And again, we all agree on one point that yes, automation is the way forward, in the sense where we can bring efficiency to do things quicker, better, smarter, with less possibility of human error. But again, this is not something that we can just take it as the final solution and then forget about our obligation. It's our responsibility to make sure that our solution that we are using, it really works and it does the job properly. So that's very important. Now, what I would like to ask actually a very interesting question that has come from the audience, and I would like to actually put this question to Alessia. So we have a question on Maltese vessel and aircraft. As to the question says, I'll read it. Can you please kindly explain the way in which Maltese vessels and aircraft are subject to sanctions? So Alessia, over to you for this answer, please.
So they are actually subject in various ways, but just as natural and legal persons. So, for example, we had cases where Maltese flagged vessels were actually owned by sanctioned individuals, and therefore such vessels had to be frozen. The same goes for aircrafts. You can't have, for example, anyone managing them who is sanctioned. They cannot carry sanctioned goods. They cannot go into sanctioned ports, for example, or sanctioned landing in sanctioned countries, or traversing sanctioned airspaces. So yes, I mean, in that way, obviously. And then we also had airlines which were, for example, actually sanctioned. I mean, and maybe you would be dealing with them for leasing or anything of the sort. So then again, you can't make economic resources available to such companies. There are plenty of ways in which Maltese vessels and aircrafts are subject to sanctions, and therefore one must be very cautious when dealing with sanctions, especially if there are dealings with sanctioned countries, I would say.
Thank you, Alessia. I'm looking at the clock and I realize that we only have 8 minutes left. So 90-minute session always looks like, you know, a very long session, but it just kind of passes in a blink of an eye. So now what I would like to do, maybe just one final comment from all of my panelists. What would it be, in your opinion, the most important thing that you would like to share with the delegates here from your perspective in terms of the organization that you represent or the industry that you present? So I'll start from my right. From the screen I can see. Alessia, over to you. What is it, something that the one final piece that you would like to say? We've got pretty much a minute for each of the panelists now.
That is too short, but I will try. Of course, if any guidance is required, please do reach out to us and we would be happy to provide you with any help that we can provide you with. Secondly, the importance of training and the training of your staff and to make them aware to what to look out for. And of course, I cannot but not say, there is this notion of de-risking. We want that our businesses continue to do good business which is allowed, and not to go on the other extreme. Let's de-risk, let's do, you know, let's be over cautious. Yes, be cautious within reasons and within limits and within the limits of the law, of course. But there's no reason to avoid good business, we would say.
Thank you. This is actually a very important point that, and I always talk about it whenever I get an opportunity. Hey, when you come across a risk, don't run away from it. Okay, look into it. Try to understand the risk. Put a control in place. Mitigate the risk. Embrace it and deal with it. Right. So what happens when you identify a risk? If you run away from that risk, that does not mean that risk is gone away. It's still there. You basically passing on to someone else and to take a burden. If you have good controls in place, they will take the relationship, they'll take the risk, they'll put the control in place, and they'll take your business, right? But again, if you, I think any good business, they should really focus on that identification of risk doesn't mean just run away. Okay, learn how to embrace it, learn how to put control in place, and don't pass it on to others. So de-risking, unless it's something which is purely maybe a regulatory breach, for example, it's a breach, that's something that you don't want to do. Of course, nobody want to conduct a breach of the regulation. That's one thing. But when there is a risk, then make a risk assessment, try to deal with it. That's my suggestion that I always share in all of the forums whenever I speak. Okay, Roxanne, over to you.
Thank you, Omar. So 3 points from my end. So first, I would like to highlight once again the FIAU's role with regards to sanctions, that it acts as an agent of the SMB by collecting information on its behalf, and that any issues that would be noted during the supervisory visits that would be carried out, such as, I don't know, late or no screening or no policies in place or insufficient policies, then they are reported by the FIAU to the SMB, and therefore any sanction-related findings would not feature in the FIAU's communication to the subject persons, because all the information would have been sent to the SMB, and then it would be up to them to take any necessary action. Something else is that any earnings which are related to breach of sanctions are considered as proceeds of criminal activity, and this would actually trigger the obligation to file a suspicious transaction report, an STR, under Regulation 15.3 of the PML-FTR, which lays down that when a subject person knows, suspects, or has reasonable grounds to suspect that funds, irrespective of the amount involved, are the proceeds of criminal activity, in that case, an STR should be submitted. And finally, I would like to remind subject persons on the guidance note that was issued by the FIAU in March of this year on the interplay between AML, FT obligations, and the restrictive measures applicable in the context of the current situation in Ukraine, which can be found on our website. Thank you.
Thank you, Roxanne. Now, Owen, I will come to you. One last piece of comment from yourself as well, please.
Yes, so I work in the gaming industry. I think throughout the past couple of years, the compliance function is obviously central to a regulated gaming business as any other regulated industry. But my advice to our compliance officers who are in this panel is to be inquisitive, do your work without any hindrance. There is obviously you have an obligation to maintain the reputation of this industry, but also when in doubt, feel free to reach out. Today we've seen and we heard actually there are various ways of educating oneself. Expert help is also readily available. Network, reach out to other compliance officers, you know, strike up a chat on social media or whatever. Generally, I find compliance officers have quite a keen sense of humor, but also like to share what they've been to and you know, build the community feeling over there. In terms of the challenges that you find every day, when in doubt, dig deeper. You know, if it doesn't make sense, do more research, find more sources.
Thank you. Don't assume. Yeah, just I think that's what I always say. Don't assume that okay, everything will be fine. When there is something which is not making sense, I echo your words, Owen, as well. Dig deeper. Just try to figure it out exactly what it is. Last but not least, Dylan, over to you from MFSA. Your last comment for this evening.
Yes, sure. So practically, Amar, just to conclude, compliance with sanctions obligation, as was rightly mentioned during this webinar, is a critical part of the subject person's framework, as it practically safeguards the business from engaging or facilitating transactions connected to sanctioned individuals or parties. So I believe that today it was a very fruitful session, whereby we delved high level into the importance of sanctions compliance from a local perspective, also with the input of other local authorities, and also from an industry perspective as well. As a concluding remark, in view of the continuous expansion and also increasing sanctions complexity, subject persons are automatically inherently exposed to an increased likelihood of risk, in this case on sanctions. So it is essential that sanction screening is adequately implemented and maintained as part of a wider set of financial crime compliance controls, and also within the risk appetite of the subject person itself. What I would like to emphasize here and conclude is that the implementation of an effective compliance program not solely protects the reputation and the integrity of the subject person itself, but also safeguards the Maltese financial sector and the reputation of the local economy practically. Thank you.
Thank you, Dylan. So now the time is over. So I know that the time has gone very quickly. Just a couple of things I would like to say at the end. Pretty much, you know, wrapping up. Guidance and support is available. Right. So please feel free to reach out to SNB whenever in doubt. And then also do consider kind of, you know, making benefit from technology, but be very cautious. Do your due diligence, do test, and I will say again, do test. So making sure if you benefit from technology, it does really work for you. And 3, invest in yourself. Okay, a training and awareness, that is something is critical for any compliance officers, right? You are the gatekeepers, right? So you are the individuals who are kind of guiding and coaching your organizations. So you're the one who are the source of knowledge. As a compliance officers, your management is looking at you to guide them, coach them. So that is very important that you you do, and even have a open discussion with the organization. And especially when we looked at one of the poll today, the lack of training has been identified as something that's very high up, like around 80% of the participants who voted on the poll, they mentioned either the training is very basic or is not available at all. So that is something I would say is quite significant that we should all take away and think about it. And the last but not least, as I mentioned previously as well, so if anyone need any help and guidance from myself or Sigma's perspective, anything on sanctions, AML, ABC, financial crime, please feel free to reach out to me. I'm more than happy to offer my help, formally, informally. Please do not hesitate to contact me at all. And the very last comment, as we mentioned earlier as well, so International Compliance Association, ICA, they are one of the sponsors for this webinar. So as a token of appreciation for all of you who actually registered for this webinar, so ICA has actually offered that they will offer 10% discount on every ICA professional qualification, whoever actually registers for this particular webinar. So anyone who like to take benefit from it, please feel free to drop me a note, reach out to us, and then I can definitely give further information on that really good opportunity. So thank you very much, everyone, for attending this event today. And I hope to see you all soon, hopefully in another 3 months' time, because we've been holding these webinars on quarterly basis, and we've always got some really good feedback, and we would like to carry on offering this service to the community for the benefit of all of you. So thank you very much, and all of you have a really good rest of your evening, and see you later. Thank you. Bye-bye.
Bye, good day.